Well, hello everybody. It's great to have you with us today, and thanks for joining us at Bardia Perry's Local Government Virtual Forum. For those I haven't met, I'm David Crease. I'm a partner in our Dispute Resolution and Advisory team, and today I'm joined by my colleagues Nick Kalapalitis and Mario Rashid Ring. Together today, we'll be talking about invoice fraud and how that impacts local councils. That's my part of the presentation. And Mario and Nick will be providing a building and construction update. Now, before we get started, I'd like to begin by acknowledging the Gadigal people of the Eora Nation, traditional custodians of the land from where we're presenting. I pay my respects to their elders, past and present, and recognise their continuing connection to our land, our waters, and our culture. I extend my respect to the Aboriginal and Torres Strait Islander peoples who might be on the presentation today. Now, just a couple of quick housekeeping things before we dive into the presentations. Firstly, questions. If you do have questions, you'll see you'll have a chat function. So if you pop your questions in the chat at any time, and we'll come back to them at the end after Nick and Mario have done their presentation. And then just be assured you take notes if you want, but we will be sending you the slides and a recording after today. And there'll also be a short survey. If you can participate in that, it'll only take a minute, and we'd really like to get your feedback if we may. Okay, so today I am talking about invoice fraud in relation to councils. So what we're talking about is firstly understanding invoice fraud risks, followed by examining relevant legal cases and their implications for councils in particular. We can then talk about the operational impact of these rulings and steps councils can take to prevent fraud, and then we'll have a summary and takeaways. Now, just to set the scene, invoice fraud is a significant issue. When I say it's a significant issue, it's a significant issue because in terms of statistics, in 2024, the Australian Banking Association reported that there was something like $224 million lost to Australian businesses through invoice fraud, through invoice email scams. And in terms of trends, while other types of cyber scams that have decreased, invoice fraud has increased over that time. So it's certainly a significant matter. What is invoice fraud? Invoice fraud, you'll probably be familiar with it. A fraudster impersonates usually the supplier of goods who needs to be paid, goods or services who needs to be paid, gives the buyer the false bank details. The buyer thinks, oh yeah, I'm sending the payment to the seller, when in fact it's going to the fraudster. It usually then only becomes apparent once the seller chases up the buyer and says, when are you going to pay me? The buyer says, well, I've already paid you, and that's when it all comes to light. So that's what it's all about. And it's a significant risk for local councils, because just think how many supplier payments you have to make yearly. You've got, no doubt, more than one member of staff who is authorising payment, who's receiving the invoices. So the capacity for there to be a significant incidence of these frauds is real and is there. And because of these high volume transactions, or potentially high volume transactions, the high volumes of transactions, it's something that local councils need to both understand in terms of risks and also the methods towards safeguarding what, at the end of the day, is public money. So let's have a look first at relevant court decisions. Now, it may be surprising to you that there's really only been two reported cases in Australia in relation to invoice fraud. So the first one is a case of factory direct fencing and Kongar International. As you see, it's a 2013 case. It's a judgment of the District Court of Queensland. And then the other case, Mobius Group and Intertech, which was a bit more recent, decision I think was December last year. That was a case in the District Court of WA. So we don't have any Australian Superior Court decisions. So for the time being, we are guided by these two District Court decisions, which were consistent. So we're not left in a position where we have conflicting decisions. So just to look quickly at factory direct fencing first. So what happened there was an Australian importer of aluminium fencing products was seeking to buy fencing products from a seller in the People's Republic of China. They agreed to do business over email. And I just remind you of the date of this. So these are things that are happening in 2012, 2013. So 12 odd years ago, things are a little bit different now, but nonetheless, they were using email. They agreed that the buyer would order the fencing products by email to the seller. The seller would reply by email, confirming the order and giving bank account details, and then the buyer would transmit the funds to the seller's bank account. They did this for a little while, and then a fraudster impersonating the seller intervened in the email correspondence, the typical modus operandi. How did this happen, you might ask? So how this happened in this instance was that the seller actually sent an email meant for the buyer to the wrong email address. It went to the fraudster's email address. Why that email address was popped up on autocorrect or automatic direction, automatic address, we don't know, but that's what happened. So the email's gone from the supplier to the fraudster. The fraudster says, aha, there's a transaction going on here. I can get involved. So as is the usual way, the fraudster then impersonated the seller, pretended to be emailing from the seller's address, gave the buyer a false bank account, requesting payment into the fraudster's bank account, and that's what the buyer did. Seller said, hang on, I haven't been paid, why aren't you paying me? Buyer said, yes, I have paid you, and that's when the whole thing came out. The seller said, well, I haven't been paid, so you need to pay me, so sued the buyer for the payment. The buyer said, well, I have made a payment. I made it to the address, to the account, which apparently was yours, and it's your fault anyway, because you owe me a duty to take care not to send your details to a fraudster, to the wrong address, and you owe me a duty of care in contract not to misdirect emails that are intended for me. So it's basically, it's your fault. Now, the court, as you'll see there from the graphic, held that no, in fact, the seller didn't owe a duty of care not to misdirect emails and to make sure its emails were going to the right place and to guard against misdirecting emails. Now, one salient fact in this case was that the seller, the buyer didn't call the seller to check the bank details. It's become pretty common practice now, I think, in most businesses that you don't just accept bank details that come in an email to you. You ring the person who sent the email or who's apparently sent the email to check that it's genuine. Now, in this case, remember, We're back in 2012, 2013, when that probably wasn't a practice. There was no phone call, notwithstanding that the buyer had become a bit suspicious. Notwithstanding that suspicion, instead of ringing the supplier or texting the supplier or doing something else, what they did do was they sent an email back saying, "Are you sure this is right? Why have things changed?" Well, of course, that email was a reply to the fraudster. It didn't go to the supplier. So, needless to say, the fraudster reassured the buyer and the payment was made. So, in that case, the Queensland District Court said, no duty, this is something very novel. To impose some new duty of care, you need a real imperative. We don't see an imperative to impose this kind of duty. So, bad luck, buyer, you've got to effectively pay twice. You owe the seller money. So, that was the first one in 2013. Then 2014, we had the Mobius Group case. So in the Mobius Group case, this is very, very, very similar to what occurred in the previous one. The significant difference is that there was an attempt by the purchaser, by Mobius, by Initech, to check the bank details. In this one also, another difference between this and the Queensland case was that Mobius Mobius hadn't misdirected an email anywhere. They hadn't done what the supplier had done in the Factory Direct case. They had just had their email account hacked. So the email account's hacked. An email apparently goes from Mobius to Initech saying there's been a change in bank details. These are the new ones. Initech, similarly to the buyer in the Queensland case, sent an email back saying, "Are you sure this is why it's different?" That, of course, that went back, yes, to Mobius's account, but as is apparently done regularly these days, the hackers are a bit more, and the fraudsters are a bit more sophisticated, and so they had, as part of their hacking of Mobius's account, they put in place a direction so that any emails coming back into the account from Initech were redirected to the fraudster's account. So they were able to reply as if they were Mobius, the genuine supplier. Another significant difference is that, according to the evidence, a staff member of Initech did what has become common practice and rang Mobius to try and verify that there had been this change, that these were the authentic bank details. Apparently, what happened was when they called, they couldn't get through for one reason or another. Whether the staff member wasn't there, it went through to voicemail, or there were just problems with connections. The judgment's not entirely clear. But what is known, or the evidence was, that although the Initech person called the Mobius office, they didn't actually speak to anyone. So, having not spoken to anyone, having got responses from the fraudster posing as Mobius, Initech paid, and it then came to light that Initech had paid the wrong person. Mobius hadn't been paid. Mobius sued to get the payment that they were due. Initech said, "I've paid once, I'm not paying twice, it's your fault." Now, this time, again, it wasn't a case of Initech having sent, Mobius having sent an email to the wrong person, which allowed the fraudster to intervene. In this case, the fraudster had hacked into Mobius's account. So what Initech said was, well, you have a duty to make sure that your security settings in your account are such that you can't be hacked, that you can prevent this kind of fraud happening. Again, this is a novel a novel duty. The court said, well, look, we've never seen this kind of duty before. Obviously, times have moved on. Things are changing, especially in the cyber world, but we still see no reason to impose this duty on a supplier. A purchaser is probably better placed to take precautions to protect itself from fraud than the supplier. So far as the law in Australia is today, the onus is on the purchaser to verify the account details, not on the supplier to make sure that its email account can't get hacked. So what does that mean for you as a local council? Essentially what it means is you have a duty to protect against fraud as the payer, and you are expected to undertake verification procedures and prompt action. So in terms of detail of that, you've got a responsibility to protect yourself from fraud. You're expected to have procedures in place to confirm, in particular, any change in banking details. It's a red flag, especially if you get it by email. And then if something out of the ordinary occurs, if you're suspicious, you need to take action. And obviously, that action doesn't mean make a call and if you can't get through, just keep going. You need to do more than that. So look at more than one form of communication. So practical steps: verification processes, education, and using more than one form of communication, and also responding quickly if you suspect fraud. So strict verification processes. Make sure you have more than one method of confirming banking details. So they might be text, they might be some encrypted form of communication, but always verify by calling known and verified contact numbers, not just those in the emails. And if you can have a second or third form of communication, use that. Now, it's all very well the executive and the risk committee perhaps knowing about that, but you've got to educate your staff as well. So they need to be trained to recognise the common warning signals and what are suspicious requests. In particular, for example, urgent requests. Hackers, it's like to build the pressure up. So it's not just a case of, oh, something's changed. It's something's changed and you need to deal with it urgently. So the staff have to be educated about these warning signs, about what the best payment practices are. And of course, as soon as a red flag goes up, or even if it's an orange or a yellow flag, tell someone, take immediate action. Now, you might think that's obvious, but the Audit Office of New South Wales reported in its 2024 report on the local governments that 35 councils hadn't conducted fraud awareness training for its staff. So it's possibly a gap, hopefully not in your council, but education isn't just a one-off thing. It's repetitive. You have to keep doing it, and it's got to repeatedly be done because the landscape changes. The inventiveness of fraudsters, it knows no bounds, and that keeps changing. So ongoing communication and education is very important. Other things that you can do, I talked about earlier, secure communication channels. So think about encrypted messaging and secure portals for supplier communications, where they've got to register on a portal and it's going to be harder for a fraudster to impersonate them. You can also look at contract conditions where you try and shift the responsibility as far as possible onto suppliers. Now, we saw in those two cases that they tried to impose, or the buyer tried to say there's a duty of care at common law in tort. They weren't able to rely on contract provisions. Now, you may be able to rely on contract provisions that govern your relationship with a particular supplier, and councils are in an ideal position to do that, because usually councils are the ones who are dictating the contract terms and conditions, not the other way around. So you might, for example, include in your contract provisions a provision that if there is going to be the supplier has to provide you with bank details at the time of contract, and that if there is going to be a change in those contract details, those bank details, it has to be done in a certain way. They have to go through certain secure communication channels. Maybe back to old school, it's actually got to be in hard copy. So you've actually got to get a hard copy notice that the bank details have changed, whether that's by, if it's a construction job, actually handing it to council's representative on site, or at least mailing it by snail mail or courier delivery physically to the council offices. So these are things you can think about putting in your contract provisions, because then you've got a chance, if the supplier doesn't do that, of saying, well, you're in breach of the contract and you're now not able to take advantage of your breach of the contract to effectively make me pay you twice. Shift the risk onto the fraudster. Now, the slight caveat on that is you can't be draconian. You can't be unfair in those provisions where you're dealing with a supplier who has a turnover of less than $10 million a year, because then you fall into the unfair contract provisions under the Consumer and Commercial Act, the old Fair Trading Act, Competition and Consumer Act. I'm sorry, yes. So the unfair trading provisions in there apply to businesses under 10 mil. So your contract provisions can't be so draconian as to be totally unfair in terms of moving the risk across. So what are the takeaways? The key takeaways and proactive strategies, two of them. Be aware that the threat remains a constant risk and how it works. Be aware that council, absent those contract provisions, is probably going to be, on current authority, responsible for the losses, unless it's an extraordinary situation. So you need to keep that in mind. And I suppose the other takeaways in terms of, and the main one in terms of prevention, is strong processes and staff education. That's the end of my little presentation on invoice fraud. So I will now pass you over to Mario and Nick to give you a building and construction update.
Thanks, David. So today we're here to talk to you about two discrete topics. The first is project delivery agreements and how they work and how council could take advantage of them. And separately, Nick is going to provide an update on some of the recent cases that we've seen in this space, together with an update on some of the legislation that is coming through. So firstly, let's talk about what a project delivery agreement is, a PDA. Now, sometimes they're given slightly different names, development agreements, project development agreements, but they all refer to the same thing. Effectively, a PDA is a legal contract that defines the terms and conditions for the development of the project. It sets out the rights, the responsibilities, and obligations for all of the parties. Now, ordinarily with a PDA, you have a party who is the landowner who enters into this PDA with a developer entity to effectively develop some sort of works or projects. And depending on how it's structured, either that developer entity then sells the asset or potentially secures an operator for the particular building once it's completed. Now, the project development agreement acts as a roadmap for the entire life cycle of the project. It talks about the scope of works, the responsibilities, it identifies critical milestones, and effectively what the end product needs to be. Now, it's particularly common in larger projects where there is a need to manage risk, ensure that there's clear communication, and still have some control over the development process without the usual capital injection that is required for a traditional project delivery. Now, the benefit, or I guess some of the reasons why a council may use it, is so that there is still some control over the outcomes, and ultimately there are still those community benefits and outcomes that are prioritised, notwithstanding there is a developer who assists with the project delivery. And it looks to align the public interest with private sector delivery. A PDA can be used by local councils for a number of reasons, and they include because it can help deliver projects efficiently and lawfully. Within the PDA document, you can build in all of these controls and mechanisms to ensure things are being carried out effectively and in accordance with any legislation. And as Nick will tell you, there's a whole host of legislation that is in the works and has wide-ranging impacts. And this is a way that can help ensure compliance with that. It's also a way to effectively leverage some of the private capital and expertise to help deliver some of the projects that are in the public interest. This form of delivery also streamlines procurement and approvals and helps shift some of the risk away from council, as well as, again, sharing some of the responsibilities with the developer. And throughout the whole PDA, you can ensure that community outcomes are front and centre, so that throughout the delivery process, we can ensure that these are an area of focus. Now, there are a number of benefits of a PDA, and broadly speaking, we can break them up into three categories. We have the legal benefits, some of the commercial benefits, and then some of the operational benefits. So firstly, a PDA provides clear accountability. It sets out who must do what and when they need to do it. So again, this is a clear way to ensure that everyone knows what is happening, they're all on the same page, and everyone knows what their part is. And this can be a key, I guess, mechanism to avoid disputes and risk down the line, because it's all documented within a single document. Now, a PDA can also help sort of bake in governance into the contract. And what I mean by that is there could be certain control mechanisms that are put in place, but equally, if there is a stage development, there could be an independent certification process to ensure that when stages are near completion, council can be satisfied that they tick all of the boxes and that ultimately what's being delivered is appropriate. So it's again a way that councils can help de-risk some of these projects. Now, again, from a legal perspective, project delivery agreement, or PDA, is aligned with some of the existing legislative frameworks and guidelines that are out there. For instance, the PPP guidelines, again, refer to PDAs and provide some guidance as to how they could be effectively used in terms of structuring, feasibility, governance, as well as some of the probity risks and the OLG reviews that may be required. Now, from a commercial perspective, PDAs can ultimately help deliver projects without council having to fork out the money and outlay the cash to deliver it. Because of the structure, council's offering up the land, the developer ordinarily will come in and develop it at their cost, and then perhaps secure an operator depending on what the facility is. So certainly there is a commercial benefit, and depending on the nature of the project, there could be a developer development rights fee that's paid, which is again a way that a project may be monetized, or some of the costs can be offset while still ensuring that there is delivery accountability. Again, having a PDA can be a useful document, not only for the council, but also for the delivery partner or the developer, because often you have a single document that sets out what is happening, the approvals pathway, the test for completion, securities, guarantees, insurances, and events of default. Now, that is a useful document to have, and for a developer then to be able to take that to its financier to secure funding, often more easily and at a better price. And that's not a direct benefit to the council, but indirectly, what it means is that council can ensure that whoever it partners with can deliver the project, and it reduces the counterparty risks. And ultimately, as part of a PDA, there is a risk shifting, I guess, mechanism where some of the construction risk, the cost overrun, and ultimately the delivery risk of a project is shifted to a developer, whilst the council still can maintain some element of control over the delivery. Now, there are certain clauses and provisions that can be built into a PDA to, again, provide some commercial levers that don't require litigation or a full-blown dispute, but still allow pressure to be applied such that the project can run smoothly. And what I mean by that are things like liquidated damages, security, default provisions, together with step-in rights. And ultimately, because these projects are being delivered by the developer, they wear a lot of the sort of funding risk with it. Now, the last category of benefits and why they may be useful for council, that is PDAs, is from an operational perspective. There is a single point of I guess, accountability. You may have a PCG group, and that group will understand where projects are up to, together with the risks and any other issues that may arise, so that council can be across any risk of delay and slippage, particularly where there are multi stages to a particular development. And equally, it won't require as many council staff to be involved in the delivery, and the council staff can be employed in other ways. There is also clear milestones and gates for completion. So it helps drive a timely delivery of the completion of works, as well as identifying the clear pathways for approvals. And ultimately, a PDA sets out everyone's responsibilities clearly, and there is a clear trail of responsibilities, which helps also deal with transparency and promoting the community's trust in the delivery of projects of this kind. Now, each PDA will be structured differently depending on its purpose and what is being delivered, together with whether an asset is to be held, whether it's to be leased, whether the developer is then going to operate the asset, or whether they're going to secure a tenant for it. But in very broad terms, each PDA will largely have these 7 features. There will be a scope together with the objectives of the project. There will be clearly defined roles and responsibilities for the council as well as the developer. There'll be milestones and staging. So there could be condition precedents, early works, together with sunset dates built in. There may be land transfer mechanisms depending on the nature of the agreement. There will be a clear documentation of the funding arrangement together with risk allocation. There will be governance provisions together with a clear dispute resolution process. And often a PDA will be accompanied by various other documents, such as a construction license. That is a document that allows the developer to go in and access the land before a lease is entered into. And equally, there could be an agreement for lease, which is contemplated by a PDA or accompanies a PDA. Now, from a practical perspective, we could think about how a council may use a PDA effectively negotiated and drafted with a development partner to deliver, say, a medical precinct. Now, in this example, it could be the case that council is the landowner, but have, through discussions with the developer, entered into a PDA wherein the developer will deliver a medical precinct or a number of medical facilities on council's land. Now, ultimately, council will retain some control over the design outcomes and what it wants to deliver, together with consultation with the developer. The developer will fund the works, will secure its contractors, and ultimately deliver the works. And in this particular instance, it could be the case that the developer also secures a tenant, and there is a long-term lease entered into to operate that medical or those medical facilities. And in a structure like this, you could have multi-party deeds, which allow developers or new developers to develop different stages, as well as multiple operators for different stages and different parts of the facility. So again, in a process like this, you can see how a PDA can be used to ultimately deliver a project through a series of stages that has the public interest at heart, but doesn't necessarily have the same risk and capital requirement as a traditional delivery model. Now, on the screen, we have an overview of, I guess, some of the benefits of a PDA type delivery versus a traditional delivery. And when we're talking about traditional delivery, what we're referring to here is delivery where council submits a tender and secures a contractor, funds the development of the project, and then ultimately either operates the facility or secures a tenant. Whereas in this PDA model, we're more so referring to a situation where the council enters into the PDA and the developer entity then is responsible for delivering the project. So there's typically a lower cost in a PDA style delivery. The works can be delivered more quickly. The risk allocation is often shifted such that the developer wears most of the risk compared to a traditional delivery where ultimately council is the one that bears the risk subject to whatever mechanisms or contracting arrangement it has with the builders and contractors that it engages. There's also a greater level of flexibility and innovation encouraged in a PDA compared to traditional delivery. And that's often because council is setting what the outcomes are and what ultimately needs to be delivered together with the standard that it needs to be delivered to. But because the developer is ultimately securing contractors and delivering the works, it can use its expertise to deliver it in an innovative way and look to utilize different solutions to ultimately procure the project. Now, in a local government context, there are some things that should be front and centre when considering a PDA or having discussions around delivering a project through a PDA. Firstly, the provisions of the Local Government Act. Secondly, whether a PDA qualifies as a public-private partnership. And now that can be informed by the value of the project together with the level of risk. And if it does qualify as a PPP, then you need to have regard to the PPP guidelines. Again, community outcomes are front and centre for these projects, and that needs to be clearly articulated to the developer. Equally, there needs to be some regard for probity and procurement processes to ensure that everything is above board and all the boxes are ticked there. And it's also essential that legal advice is obtained, not just at the documenting stage, but equally during the negotiation, to ensure that what can be a fairly complicated project delivery is appropriately documented and gaps plugged. Now, the key takeaways from all of this are that PDAs are a strategic tool that can be used by council. Now, again, it's one of a number of tools and project delivery models that could be adopted, and it's really a matter of trying to work out whether it's best suited to the particular project in mind. Now, PDAs can be used to deliver complex projects. It can help share risks with a developer, but still allowing council to retain some level of control. Because of the complexity of some of these projects, they need to be carefully planned, structured, and during the course of the project, have appropriate oversight. Now, PDAs, again, you can see are supported by the legislative framework and guidelines in New South Wales. So they aren't novel, they're not new, they're something that are tried and tested, and again, can be used appropriately. And ultimately, if used in the right way, will help councils achieve better outcomes for communities and payers. Now, I'll hand over to Nick to talk through some of the recent cases together with some of the upcoming legislation.
Thanks, Mario. Very useful content. Look, I'm going to try and be brief, obviously due to time. Some of the cases I'm referring to have a bit of a long history, can be a little bit dense, but I'm going to try and simplify it as best as I can. So the first case is the High Court case of Pathburn. And Pathburn, obviously it's made it to the High Court, so it's had a bit of a checkered past, but Pathburn involved a residential apartment complex in North Sydney, where the owners corporation sued the developer and the builder due to a number of defects as a result of the development. Now, what traditionally was the case, particularly with Supreme Court litigation, but across all jurisdiction, was that you could, or the builder and developer could plead what we call a proportionate liability regime. So what that meant was that they could, in effect, for example, if there was a plumbing defect, they could blame the plumber. If there was an electrical defect, they could blame the electrician, and so on, down to architects. And what that would mean is that the developer and the builder, in most cases, would basically say that they are 0% liable for a lot of the defects, and it all lays in the hands of the subcontractors who undertook the relevant works in relation to that defect. The case here involved a claim, amongst others, in relation to the Design, Building and Practitioners Act. So under Section 37 of that Act, it allows a party to sue under what's called a statutory duty of care. And that's what the Owners Corporation did. And what ultimately the Owners Corporation did is they brought an application to the court to say that in this case, which the builders did seek to do a developer, the builders couldn't rely on this proportionate liability as a result of this legislation. As I said, it made it to the High Court. There was conjecture up until that point, and the High Court unanimously found that the duty under Section 37 is a non-delegable duty. So what that means is the builder and developer are 100% liable for all the defects on a particular construction project. What it also means in a practical sense is that now the builder and developer need to cross-claim against any party that they say ultimately caused that defect. So again, as I mentioned earlier, whether it's an engineer, whether it's an electrician or plumber, waterproofing, fire. So they would need to cross-claim against all of those parties and join them into those proceedings. And probably in that context of that, and for us as litigators, it's probably going to make litigation complicated in a sense. It will make it longer and a lot more parties more involved in that process. But ultimately, the builder and the developer are 100% liable. So they can, if they choose, just sue the builder and the developer. So obviously, that's what you just need to keep in mind. It also means that you can recover full costs for any remediation works from the head contractor. The other case I'm going to talk about briefly is a 2025 case of Acciona and Enemec, and that was a case that involved the Security of Payments Act. In short, what occurred in that was that Acciona, who with some other joint venture partners was engaged by the state government to undertake works on the M4, M5 link, had contracted with Enemec, who's an electrical contractor, to undertake electrical works on the project. Acciona said that it was able to claim on a undertaking that had been provided by Enemec by a bank in the value of $9.2 million. Acciona proceeded to make a claim on the bank, and it ultimately received the amount of $9.2 million. Unsurprisingly, Enemec didn't take that too kindly, and what it did was issue a payment claim to recover, amongst other things, the value of that undertaking that had been claimed in the value of $9.2 million. Acciona, so what had happened in the adjudication process was that ultimately the adjudicator determined that that was able to take place pursuant to the Security of Payments legislation. That went on to the Supreme Court for that determination to be quashed by Acciona. And in the Supreme Court, at first instance, it did say that, in their view, Acciona, in their arguments, was right, and that the Act did not allow a party to make a payment claim to recover a claim under a security, basically a security clause in a contract. So that would include a bank guarantee, retention monies, or in this case, as I said, an undertaking. And basically found that Enemec had to return the monies. Enemec took that to the Court of Appeal, and the Court of Appeal ultimately found that the Supreme Court was wrong, and that the construction, so it looked at the construction of the wording of the Security of Payment legislation, and the Supreme Court of Appeal took the view that a payment claim does not need to be purely for construction work. And that was the initial argument that was made by Acciona. And because of that, Enemec was able to rely on the payment claim that it had made, and it was able to, through that process, seek the recovery of any monies that had been paid to Acciona by making a claim on any security clause. So the upshot of that, particularly for councils in this case, is to ensure that you've got clear and unambiguous security clauses within your contracts, because what occurred, because the claim in the court's view was wrongful, was a wrongful claim under the security clause, Enemec was able to claw it back through the Security of Payments process. So it's important that you make sure you've got your contracts, as I said, to be clear and ambiguous, particularly with these clauses due to this Action and Intimate case. The other update I just want to briefly go through is the Building Bills 2024. Now, some of you may have heard of it. It's sort of been hovering around now for, I think, nearly 2 years. And the reason I say that, it seems that the can keeps being kicked down the road with this bill. It is presently back with the state government. There was an extension up until October last year for some more submissions by various industry bodies. And as I said, it presently sits there. So what ultimately will be the outcome, it's still a little bit vague and unclear, including for us as lawyers. But what is coming out and what we've seen as I've got there and what the intent of it is basically to consolidate 9 existing acts. For example, the Home Building Act, the Design Building Practitioners Act, the Architects Act, move certain certification compliance processes out of the EP&A Act into this new bill, and other legislation. So it is basically seeking a major overhaul of the current legislative regime, and to that extent is probably going to bring around fairly fundamental change. Ultimately, the intent is by government is to simplify and make current legislative processes more transparent. As I said, at this stage, I think it's a little bit unclear that will occur, given we don't ultimately know what this legislation means. But there is, as I've got there, and identified what some of this may entail, and particularly what may be relevant to council is particularly in relation to occupational certificates, the certification processes, and the broader powers that ultimately the Building Commission will have to oversee certain works and certain certification processes. There is also slated a new building compliance and enforcement bill, which also introduces stop work orders, rectification powers, and as indicated, stronger penalties. So there isn't a fair bit of change on the horizon. Obviously, the statutory duty of care extends to all buildings, the decennal liability insurance to also protect against serious defects for a decade. So one of the takeaways is to just ensure that councils are aligning their planning controls with certification workflows and enforcement protocols with ultimately what will become the new legislative framework. But rest assured, when we know more, we will provide updates to you all once it does become a little bit clearer as to what the framework does look like. So that's it from me. I think if we have any questions, we will deal with those. But that's a wrap for today's session. Thanks so much for spending the time with us, and particularly your lunchtime. We hope you picked up some insights. If you'd like to chat further, as I said, David, Mario, and myself, we're happy to connect after this and take any questions. But enjoy the rest of your day, and we do hope to hear from you soon.
So I think one of the questions was, are PDAs usually created in-house, or is it better to get specialised support? And it was raised in the context of council owning land, currently in an EOI process for a developer for a hotel on this site. It'll be a long-term lease. It's the first time engaging with this type of project. What advice will you provide? My view is it's certainly helpful to get that specialised advice, because particularly for, say, a hotel, it's a significant development likely to cost a fair bit of money. So it's important to ensure that it's appropriately structured and some of the development risks are properly balanced. So it's certainly something that I think would benefit from specialised advice, at least to understand at the outset, well, what are the parameters, who will be responsible for what? And once that is sort of mapped out appropriately together with the appropriate sort of probity advice and everything else, to then take it and document it in a long form PDA. Nick, David, do you have any comments about?
No, not on that question. Well, that's all the questions. So, but if you do have further questions, please don't hesitate to shoot them in by email, and one of the three of us will respond promptly. As I said at the outset, you'll get a recording and also these slides, and please don't forget the survey. Enjoy your afternoon. Thank you all.
Thank you, everyone.
Thanks, everyone.